The factory floor is loud, the shift is finally over, and your boss calls you into the front office. He doesn't sit you down to chat about your weekend. He looks you dead in the eye, tells you the company is moving in a new direction, and your services are no longer needed. You pack your toolbox, walk to your truck, and your mind is racing because you have a truck payment due on Friday. You spend the entire drive home trying to figure out exactly what you did wrong to get fired, searching your brain for a single massive mistake. I am going to tell you exactly why searching for that mistake is the biggest error you can make right now, and why understanding employment law can save your house if you know how to play it right. What you've to understand first is the concept of at-will employment. At-will employment means your boss can let you go at any time, for any reason, or for absolutely no reason at all, just as long as the reason isn't specifically illegal. Every single state except Montana operates under this massive umbrella of at-will employment right now, and that fact completely changes how you to look at your job. When you work at will, your employer doesn't need a massive pile of paperwork to show you were bad at your job to show you the door. This is where the first giant mistake happens. People drive home thinking they can easily file a wrongful termination claim against the company because they did absolutely nothing wrong. A wrongful termination claim is a specific legal charge that says your employer fired you for a reason that actively breaks the law. Believing you've a wrongful termination claim just because you were a good worker or because you never missed a single Friday will absolutely destroy your case before you even start building it. Being an excellent employee doesn't magically protect you from being fired under at-will employment. A company can make a terrible business decision. They can fire their absolute best worker simply because they don't like their attitude, and the courts won't stop them. Instead of wasting your energy trying to prove you were a great employee, you need to be looking for the illegal exception. While at-will employment gives your boss massive power to fire you, the law draws a very hard line in the sand against certain reasons. The law calls these protected classes. A protected class is a group of people legally shielded from employment discrimination based on traits like race, religion, national origin, sex, age, or disability. This shield varies by state, with many states adding their own protected traits like sexual orientation or marital status. You can't just say they fired you for no reason. You've to figure out if they fired you for an illegal reason. This leads straight into the second massive mistake people make. When a blue-collar worker gets suddenly fired, they immediately panic and try to squeeze their normal personality clash into a protected class to make a quick legal case. They get written up for being 5 minutes late to the machine shop. They get mad about it, and they suddenly tell everyone they're being targeted because of their age. This is a fatal error that will get you laughed out of the room by a judge. To win a case for discrimination, you can't just be a 40-year-old who got fired. You've to prove they fired you specifically because you're 40. That's a massive leap in the law, and it requires evidence. The smart move here is looking for direct evidence instead of just throwing spaghetti at the wall to see what sticks. Direct evidence means you've something concrete showing the decision-maker held a bias. If your supervisor makes a cruel joke about your religious beliefs right before handing you a termination slip, that's direct evidence. If the company suddenly fired every woman over 50 in your entire department during a restructuring, that creates a pattern of evidence you can actually use. If you don't have that specific, bias-driven motive, you generally don't have a discrimination case, no matter how terribly they treated you. When this happens, you need to consult an employment attorney to look at the actual facts. The third mistake usually happens right before the firing, and it costs people thousands of dollars. People think their boss can't change the rules on a whim, so they stop working when they hit 40 hours and wait for overtime approval. Then they get fired for insubordination. You must also be extremely careful about severance agreements. A severance agreement is a legal contract where the company offers you a few weeks of extra paycheck, and in exchange, you sign away your absolute right to ever sue them for anything that happened while you worked there. People get fired, they panic about the mortgage, and they quickly sign the severance paper just to get the quick check. If you have a real, valid wrongful termination claim based on discrimination, you might be throwing away tens of thousands of dollars just to grab a quick 3-week severance check. You need to take a breath, read the entire paper, and have an attorney look at the contract before you ever sign your rights away. The sixth mistake people make when they finally realize they have a valid case is running to the completely wrong building. They go to the local police department or the local courthouse to file a random complaint against the business. You've to understand exactly what the EEOC is. The Equal Employment Opportunity Commission is the federal agency that actually enforces the laws against workplace discrimination. Because the local police don't handle workplace discrimination, you've to go through the proper government channels to get justice. The massive error here is missing the strict deadline. With the EEOC, you can't just wait 3 years until you get your life together to file a claim. You generally have a very tight time limit, usually 180 days from the exact day you were fired, to file a charge of discrimination. If you miss that deadline, your massive lawsuit completely disappears, and it doesn't matter how much direct evidence you manage to pull together. The deadline is absolutely unforgiving. Instead of going to the local cops, you need to file your charge with the EEOC or your specific state's equivalent agency. You fill out their specific form, you attach your evidence, and you let them investigate the company. Getting an attorney to help you file this charge correctly is the smartest move you can make, because an experienced lawyer knows exactly how to phrase the facts to meet the strict legal requirements. The seventh mistake is ignoring the whistleblower protections. A whistleblower is an employee who reports their employer's illegal activities to the proper authorities. If you got fired the exact week after you told the environmental regulator that your boss was dumping toxic chemicals into the sewer drain, you probably weren't fired for being a bad employee. You were fired for being a whistleblower. People mistakenly think they can just casually mention safety issues to their supervisor and get whistleblower protection. The law doesn't work that way. To get whistleblower protection, you usually have to report the illegal activity to an actual government agency, not just complain to your shift manager. If you fall into this category, the timelines to file a claim are often even shorter than regular discrimination cases, so you have to move fast and document exactly who you talked to and when you made the report. The eighth and final giant mistake is believing in the myth of the unsigned contract. People often think that thick employee handbook they were handed on their very first day acts like an ironclad legal contract. An employee handbook is generally just a set of company guidelines, not a legally binding promise that you'll keep your job forever. Unless you actually signed a specific document that explicitly states you can only be fired for specific causes, you're generally still an at-will employee. Relying on a generic handbook to save your job in court will leave you completely empty-handed. You always have to remember that employment law changes rapidly, and the specific details of every single law vary wildly depending on the state you live in. What is considered a protected class in California might be completely legal to fire someone for in another state. The rules aren't the same everywhere, so you can't apply your buddy's experience from 3 states over to your own kitchen table problem. If this breakdown gave you the actual tools to figure out if your firing was just bad luck or an illegal move, pass this video along to a buddy who might be stressing over an unexpected pink slip. Make sure you subscribe to Scribble Law so you always know the actual rules before a massive corporation tries to play games with your livelihood. What is the absolute worst reason a boss ever gave you for letting you go? Drop it down in the comments.